Hello and welcome to Thinking Competition, the podcast by CS Associados, focusing on competition, business trends and economic regulation. This is a free zone for critical thinking on the markets of today and tomorrow. We want to challenge commonplace ideas and try to connect the dots in a rapidly changing world. We want to keep on asking why. Join us on this journey.
Hello, everyone. Welcome back to another episode of Thinking Competition, the CS Associados podcast on antitrust and economic regulation. We are thrilled to have with us today Professor Richard Whish of King's College London. Emeritus Professor of Law at King's College London, to be correct, but I think he dispenses any further introduction. Professor Whish, thank you very much for taking the time to join us today.
Pleasure to be here.
I know you have a very busy schedule, but we'd really love to hear your opinion on a few trends or a few kind of macro topics, if you will, that have been on our minds more recently. I think the first topic that I would like to bring to the table has to do with cartel enforcement. Now, one of the perhaps unintended side effects of the exponential growth in private enforcement over the last few years, since the 2014 directive, seems to have been a noticeable decrease in leniency applications across many jurisdictions. And the reason that's often cited for this is that cartel members now, faced with huge damages claims down the road, make a different kind of cost-benefit assessments and lose the incentive to come forward. But the views on this seem to be mixed. For example, I think it was towards the end of last year that in the UK, either October or November, the CMA brought forward a proposal for the UK government to legislate in order to grant Type A leniency applicants full immunity from private damages claims. Not sure how that proposal has progressed, but on the other hand, for example, from the Commission, and you see this in repeated statements, for example, from Maria Jaspers, the head of unit for cartels at DG Comp, the Commission seems to think that no changes are needed. Leniency is working well, allegedly, and most of all, proactive cartel detection, notably using AI-powered screening tools, for example, is delivering a robust pipeline of investigations. How do you see this? Are cartel investigations really dying from private enforcement, or is the system balanced enough to still catch most serious cartels?
Well, look, I mean, this is a very interesting question, and there do appear to be fewer cartel decisions in Europe now than there were, let's say, 10, 15 years ago. But I think this is quite complicated. And I think it would be far too simple to suggest it is because of damages that we're getting fewer leniency applications, and that's why there are fewer decisions. I think it must be a bit more complicated than that. I mean, the first thing I would say is, and maybe this is incredibly naive of me, but maybe there just are not as many of those kind of heavy duty hardcore cartels as there used to be. I mean, my competition law career goes back for a long way, and there was a time when there just seemed to be an endless conveyor belt of decisions, for pre-insulated pipes and gas thermal insulated switchgear and transformers and power cables and God knows what.
Lots of industrial products markets, yeah.
Exactly that. And there was a time when there were lots of those, and there were also lots and lots of chemicals cases throughout the 90s and the noughties. And I think that when the immunity leniency programs were first introduced in the United States, then followed by the Commission in Brussels, that did unearth a huge number of cartels. And, it kind of took the authorities 5, 10, 15, 20 years to work through all those cases. But maybe the effect of all those decisions, coupled with the huge fines that are now imposed in many of these cases, Imprisonment is a possibility. I mean, there's far more likelihood now of there being a criminal regime in a country where you're guilty of being in a cartel. We in the UK and some other jurisdictions now have company directed disqualification, which attaches personal consequences to the individuals who are involved in these cartels. And we've had quite a lot of company-directed disqualifications in the UK now. That must have made some people sit up and take notice. We've got a policy in the UK now that if a company is found guilty of bid rigging in relation to public sector contracts, then by law they can be disbarred from participating in future rounds. So there's a lot of history. There has been a lot of enforcement, and maybe it has changed the hearts and minds of some businesses. Now, of course, added to all of those sanctions I've just mentioned, you've now got the damages claims, and damages. The possibility of damages must have a significant impact on the incentives to cartelize. Forget the incentives to blow the whistle. That's a different issue. But if you're seriously as a company thinking, shall we talk to our competitors about prices? What are the risks? You're going to be told about possible imprisonment. You're going to be told about damages. You're going to be told about company directed disqualification. And you're also going to be told that there is an enormous industry out there now of damages litigation in the UK, collective claims, quite a sophisticated funding market now that brings brings more claimants into the market. So the damages bit, to my mind, is a very important deterrent. And so that in itself might be having an effect on behaviour. So that's simply to suggest that maybe the current suite of competition law tools has deterred some cartel behaviour. A different possibility is that because so much is now known about hardcore price fixing, maybe firms are trying to manipulate the market in more subtle and in more nuanced ways that are more difficult to detect. And it is interesting to see how much authorities are looking at things like hub and spoke conspiracies and price signaling, and is there such a thing as algorithmic collusion, and so on and so forth. So maybe what once would have been very obvious cartel behavior has been suppressed. Maybe there's other stuff going on. And of course, it's going to be more difficult for competition authorities to detect that kind of behavior, but they're obviously doing their best to do so. A related point to all of this is, I find it very amusing, sort of looking at the world of competition law practice today, using the term practice in a very, very broad sense, to look at the whole constituency of people that are involved in this business. Think of, across 140 regimes in the world, the number of lawyers, economists, officials in competition authorities, conference organizers, professional trainers, lobbyists, etc. Surely more people know about competition law today than at any point in history. And one has to hope and believe that this increased awareness has some effect on behavior. So maybe there just is less cartel behavior than there once was. A different point I would make is competition authorities have ever increasing numbers of things to do. If you go back to the Commission in the 70s and 80s, what did it do? In an average year, it did about 6 or 7 cartels, 4 or 5 export bans, a couple of RPMs, and maybe an abuse of dominance case. Think of what competition authorities have to do today in 2026, all the additional competences that they've being given, all the advocacy work that they have to do, having to address the problems of digital platforms and digital markets and all the new phenomena associated with that. I suspect that authorities just have fewer resources as a percentage of the totality to spend on cartels compared to all the other things that they've got to do. So those are some general thoughts about it, but your question is specifically about damages and is it inhibiting leniency? There must be cases. There must be cases when, if you're doing the risk-benefit analysis, I can see how a company might say, well, if we blow the whistle, we're exposing ourselves to a damages claim. And, actually, it was all a long way in the past and the limitation periods are running. And with a bit of luck, we might be able to last out long enough. Or I can see in another situation, you might get advice from your legal advisors that the fines in this case might be in the region of 100 million. On the other hand, the damages exposure might be 1 billion. Obviously, that is going to have an effect on the incentive to blow the whistle. So it's obviously important, but I don't think it's the sole way of explaining the decline in the amount of enforcement. Now, on your point about immunity, or could you sort of fiddle with immunity in some sense to give immunity from damages at least to some extent, and might that change the incentives to blow the whistle? I'm very skeptical about that. Of course, the damages directive did have a little bit on it, if you remember, the stuff about joint and several liability and whatever.
Yeah. Mm-hmm.
But it seems
there is
to me that
some degree of protection and limitation, although rather limited, if I recall. Yeah.
Well, and it is very limited, and that's kind of my point. It is so limited that I wonder if there's ever been a case where the availability of some immunity, but not very much, did that ever tip the balance in a real live case between blowing the whistle and not blowing the whistle? I've got my doubts about that. Yeah. Now, my understanding is that in various civil law systems, constitutionally, it is not possible to take away the right of a victim to damages who has suffered from tortious or delictual behaviour. I believe that's one of the reasons why the Commission with the damages directive proposal didn't go further down that line, that there were just major legal, even constitutional problems
issues,
in the way of granting immunity. And in principle, I don't find myself very comfortable with it anyway, because suppose you've got a cartel consisting of two firms, and there have been plenty of cartels consisting of two firms. One of them blows the whistle, so we decide to give them immunity from damages as well as from fines. The other one is now insolvent. So where does that leave the claimant in a damages claim? I mean, it's not a fanciful example. I can think of
it's conceivable,
cartels consisting of two firms. So a proposal of this kind would simply take away the ability to claim damages. Well, that doesn't seem to me to be good in principle. And if it is also true that in some legal systems it's not possible to take away the right to damages, it seems to me that we're not going to get very far here. But in the United States, they have treble damages. So then you can have single damages for the immunity applicant. But I haven't heard anyone seriously suggest in Europe that we should start by trebling the damages so that we can then de-treble them for the immunity applicant. I mean, my God, that would be truly controversial.
That would be a revolution, yes. Yes. So, thank you very much. It's lots of things here. So the virtuous interpretation might be perhaps this is deterrence finally working.
Yes.
And that might be a positive take. Professor, the second topic we had lined up to discuss with you today, this is rather a cheeky question on my part, has to do with Article 101. Now, a huge amount of debate and a huge amount of case law has focused on what type of behavior can or should go into the object box, which has shown a remarkable propensity to expand non-stop. But the question of what kind of conduct can or should go into the effects box, if you will, so conduct that is not presumptively anti-competitive, but requires actual economic analysis and demonstration of a negative impact on consumers or on competition more generally, the effect side of the restriction seems to be largely ignored. To me, as an antitrust practitioner, it seems like almost anything gets treated as per se your object by default almost. And just to give you some local context, Portugal has had an independent competition force of the Portuguese Competition Authority since 2003, so going on a quarter century almost. And as far as I can recall, not one single Article 101 case, so anti-competitive agreements case, was ever brought based on anti-competitive effects or based solely on anti-competitive effects. And so the cheeky question here would be, is the effects box, in your view, doomed to remain an empty box? What's going on and what does this mean?
Okay, well, this is all very fascinating stuff, of course. And I will adopt the language of object box and effect box because I think I was the first person that ever used it in an edition of my book. So
you have the copyright on this. I should have said that, sorry.
Well, I don't particularly want it, but anyway, I think I've got it. But I actually find this object effect business incredibly frustrating, quite frankly. I don't understand why we're still having case after case on this go up to the Court of Justice, because there is literally every year there will be one, but often 2 or 3 or 4 cases on whether something was in the object box. And I think people have really, I don't know, somehow they've got it wrong. It's not as difficult as it appears to be. So what is there to say about this? Firstly, your words there were that the object box seems to have a remarkable propensity to expand. And people say this all the time. Is that true? Is that honestly true? I'm really not sure that it is at all. Now, obviously, it is possible that from time to time a new type of agreement might be added to the box. Maybe that's because it's a kind of agreement that didn't used to exist and it's started to appear in markets, and so it needs to be tested, and it gets tested and it goes to the Court of Justice and it ends up in the object box. Well, I can think of an example of that, which is pay for delay agreements in the pharmaceutical sector. Yeah. And we've now had 4 judgments, I think, in the Court of Justice, Generics UK, Lundbeck, Servier. Recently, we've had Teva. So this has been going on for about 10 years, and the Court of Justice has come to the conclusion repeatedly that, depending on the facts of the case, because it always depends on the facts of the case, if you have consideration moving from the patent owner to the would-be entrant, in circumstances where the only possible explanation for that payment is that the parties intended to abandon any competition between them, that's a restriction of competition by object. Is that surprising? I don't find that surprising at all. To my mind, that is a variant of market sharing. You could have a market sharing agreement, I'll have Spain and you have Portugal, or you could have a market sharing agreement that says, don't enter Portugal, stay in Spain, and it's all the same kind of thing. Well, that's what's happening with pay for delay. There's nothing particularly radical or weird or surprising about that. Of course, it does require, in an individual case, deep analysis of the evidence, because there may be explanations for the payment or the consideration other than an intention to abandon competition? Well, that's part of the legal, economic, and factual context of the case. And it shows, incidentally, that even an object case can require lots of evidence, but what it does not need is lots of evidence of an effect on the market. Why should you have to do a deep effects analysis if what the agreement does is to prevent A from competing with B? How much more effects analysis do you need in that situation? So that's an example of in a sense, a new kind of agreement entering the object box, but it's simply a variation of the idea of market sharing.
Yeah.
Now, there have been other cases that have gone to the Court of Justice where something had been put in an object box and then the Court of Justice removed it. And I'm thinking of carte bancaire, which is the most important modern judgment on object and effect. Yeah. And that, if you remember, is where the entrant banks were required to pay a higher fee for access to the network than the incumbents who created the network in the first place. And the Court of Justice says, well, actually, that isn't an obviously, that is not an agreement that obviously restricts competition by object. And so that was rejected from the object box. But of course, the Commission had run that case on the basis of both object and effect.
Yeah.
And when it went back to the General Court on effects analysis, the General Court said it did have an effect on competition, which also, of course, contradicts your point that the effects box is empty, because in that case, in the end, the Commission won on effects rather than object. Now, some of these other cases that go to...
It's an obvious example, yeah.
Yeah, some of these other cases that go to the Court of Justice on object restrictions, I honestly find myself asking, why did they go there in the first place? And since I'm talking to you in Lisbon, I will mention Super Bob Bebilas, the resale price maintenance case from Portugal. So that went up to the Court of Justice, and then the court says, well, of course, you've got to look at this in context and blah, blah, blah. You can't just say it's RPM, so it's object. You've got to look at it in context, because that's what we've been told to do by carte bancaire. And then all the law firms in their blogs say, this shows that the law on object restrictions has totally changed. It doesn't. It just means that the Court of Justice ticked the boxes that they were required to in by carte bancaire. And what was the conclusion in the end? The RPM was a restriction of competition by object. So I never really understood myself why that case went to the Court of Justice in the first place. Now, on your point about is the effects box empty? Well, actually, last year, a case went to the Court of Justice from Latvia, the Latvia car warranties case. And that was a case where the Latvian authority looked at the warranty and aftermarket market in Latvia and did not pursue object analysis. They ran the case on the basis of effects. And the Article 267 questions that went to the Court of Justice were about whether the effects test was satisfied in that case. And the Court of Justice said, yes, it was. So, you know, there's an example of the effects box being deployed by a competition authority. A different point I will make, however, and maybe this sort of relates to the Portuguese experience you've described from 2003, I talked to lots of competition authorities around the world, actually, and a sense I get sometimes is that some authorities think that this effects analysis, God, it's just all too difficult. We don't want to go down that road. It's going to take years to do it, and so on and so forth. So do they shy away from bringing effects cases? Now, I don't know if they do, but I suspect that some may do. in simplistic terms, it's easier to run an object case than an effects case. So maybe authorities are hesitant to do effects cases. Now, if they bring a case that should be done on the basis of effects, but they try to force it into the object box, well, I think that's totally wrong in principle. And of course, there are appeals and there are references to the Court of Justice. And if something should not be in the effects, if something should not be in the objects box, it should not be forced into the object box. I'm absolutely clear about that. So I think authorities should have the courage, if you like, to do some effects cases. I could almost see a case for saying, on principle, an authority ought to do one or two effects cases under 101, just so that they know technically how to do them. I think it's a good thing for the skill set of the authority to do an abuse case and an effects case and a whatever. And what I would say is, of course, in some cases, effects cases might be difficult, but it's not rocket science. It's not that difficult. I mean, what is a merger case? It's an effects case. You say, what's the world going to look like in the future with this merger? What's it going to look like without the merger? What's the relevant market in which the merger is happening? What's the theory of harm? That's what you do in a merger case. And in terms of decisions and outputs, the majority of decisions and outputs of authorities are merger cases. So they're doing effects analysis all the time. So what's so different about a 101 case?
And in fact, sorry to interrupt you, but in a 101 case, it might even be easier because in merger control, obviously you're looking at effects prospectively, so you're hypothesizing the future, whereas in a 101 case, you have the behavior behind you, so you can, in theory, at least collect evidence, past evidence.
Absolutely,
and
100%. Yeah. So I do find it strange that we still spend so much time on all of this. I would make one final point about it, incidentally. I understand why the focus tends to be on object restrictions from the party's point of view. There is a perception that if something is a restriction by object, it cannot be defended under 101(3). That is a perception. It's legally incorrect.
Wrong, yeah.
It is simply wrong, but I know it is the perception. And I've even had people in authorities saying to me, but if it's object, then you can't have a defense. Let's call it an efficiency defense. And it's just simply wrong. And, when I was starting out on my career, a long time ago, in the days when you had notification of agreements to the Commission, including for individual exemption under 101(3), it wasn't unusual to have a decision in which the Commission says, well, we think there is a restriction of competition here. On the other hand, it produces an economic efficiency, and so we give it individual exemption under 101(3). And it was rather good in a sense because it meant you got fully reasoned decisions on the application of 101(3). Now,
and you got parameters. You got the parameters and criteria you could work with. Yeah.
But since Regulation 1 and the abolition of notification and individual exemption, and I'm totally in favour of Regulation 1, incidentally, I'm not calling it into question whatsoever, but a necessary side effect of it has been to eliminate all public discussion of 101(3). Because you do not get decisions in which the Commission applies 101(3). You get decisions in which it says 101(3) doesn't apply, but that's normally because the case is about some hardcore cartel, which is an object restriction. Of course, it's not going to satisfy 101(3) because it doesn't produce efficiencies. So I feel that we've kind of lost something somehow. And I would like to see, in some sense or another, some positive applications of 101(3), which perhaps could happen if in the future there's more informal guidance, because there might be some initiatives around sustainability, say, that on the one hand do inhibit competition in some senses, and yet that inhibition may be beneficial because it achieves some desirable economic, sustainable, whatever outcome.
Yeah, I feel horizontal cooperation is going to be rather more important in the future, and typically horizontal cooperation cases which fall outside the more hardcore
Yes.
situations do require a more detailed analysis, and for me most cases would be obvious candidates, at least for a 101(3) argument. So thank you, Professor. It's perhaps my whole view on this object box and effects thing is in fact very much molded by a local view. So perhaps this is a national topic most of all. And in fact, it is a shame that the 101(3) discussions on what constitutes relevant efficiencies in an agreement has more or less dissolved into oblivion. It's a shame. So let's hope for informal guidance in future. My next topic and question to you has to do with Article 102, and you might be noticing a common thread to these questions. They're very much coming from the antitrust practitioner's point of view, and so a certain, well, I wouldn't call it anti-enforcer bias, but a rather grumpy attitude to the way that enforcement has been moving more recently. So under Article 102, in the summer of 2024, so a year and a half ago almost, the Commission published new draft guidelines on Article 102 and exclusionary abuse. And these draft guidelines seem to depart from the case law on several points. Notably, there seems to be a great emphasis on presumptions of exclusionary conduct, even outside this categorization of naked restrictions, which might better be called object abuses, if you will. And there doesn't seem to be a great deal of support in the case law for some of the positions the Commission is arguing in the draft guidelines. For example, there's a general thread going through the guidelines that almost make the existence of exclusionary effects a foregone conclusion in many, if not most cases. Paragraph 72, for example, and I need to quote this because the wording is really quite fantastic. It is not necessary to prove that the conduct resulted in direct consumer harm, i.e. that the dominant undertaking has effectively influenced to the detriment of consumers, prices or other parameters of the competition. Now, the final guidelines haven't come out yet. I think the Commission might be waiting for some relevant judgments. Google Android, for example, comes to mind. Not sure when that's coming out. But how can we reconcile if the final guidelines don't adjust the Commission's position significantly and stick to the initial draft? How can we reconcile this with a few judgments, or more or less recent judgments by the EU courts in cases such as Intel, Post Denmark, I think Qualcomm, for example, where the need for an exhaustive effects-based economic analysis under 102 was really emphasized? And does this mean that the Commission might be trying to bypass the case law, reverting to a more formalistic approach and kind of reverting its economic-based analysis approach, which was very much the thrust and the focus of the 2008 guidance, for example? How do you see this?
Well, gosh,
Sorry,
I hardly know.
I've swamped you.
I hardly know where to start. I know what the defence bar says, and these things are said repeatedly, and they become a general refrain, and they're chanted around the competition village repeatedly, that the Commission is trying to depart from the case law, it's trying to make the law stricter, so on and so forth. I just think this is completely and absolutely wrong, frankly. I'm sure the draft guidelines could have been written in a way, shall I say, that would have caused less controversy. Any document can be improved upon, and I dare say that what comes out in April will look significantly different from what we've had before, but I do not know. I'm not party to the process in any sense whatsoever. But I think a lot of this criticism is absolutely wrong, quite frankly. Now, to begin with, you said there that you find it very difficult. I think it's paragraph 72, when you say the Commission says that it's not necessary to prove direct consumer harm to consumers in the form, say, of higher prices, which would be the most obvious analysis of effects that one could come across. But I could cite 10 judgments of the Court of Justice that have said explicitly that these cases, whether they're object or effect cases, 101, 102, it's not only about harm to the end consumer. And in particular, that a practice or an agreement that causes harm to the competitive structure of the market, that can be a basis for intervention in and of itself. So there's nothing incorrect about what the Commission said there. There was a judgment just before before Christmas of the Court of Justice in a copyright collecting society case from Czechia, where it specifically says it's not just about harm to consumers, it's also about harm to the competitive structure of the market. And the same chamber of the Court of Justice said that twice in, I suppose it was 2024, in the SEN case and in the Unilever case from Italy. It's been said in the Google cases. It was said by the Court of Justice in the T-Mobile case under 101, where the relevant authority had not looked at the price, the end price of mobile telephony. It was looking at the commissions that were being made available to agents. So there's absolutely nothing controversial about saying that harm to structure is equally as relevant as harm to the consumer, and specifically the end consumer. You then mention Intel and Post Denmark, incredibly important judgments, where the Court of Justice did say that there had to be effects analysis, or more specifically, actually, in Intel, that if Intel produced a report arguing that there were no effects, then as a matter of proper administration, the Commission had to react to that
take those on board
argument and either disprove it or accept it. So yes,
that's a reversal
the Court of Justice has required effects analysis, but let's face it, that arose in cases that have always been particularly problematic and difficult. In Post Denmark, where you have differential pricing for different customers, and it's not obvious whether it's above cost or below cost. Could this kind of behavior be exclusionary in an anti-competitive manner? Intel, the lifelong controversy over rebates, discounts, incentives, so on, as rollback rebates as opposed to non-rollback rebates. Of course, that's fantastically difficult stuff. Of course, the theories of harm are speculative. So, of course, there has to be better evidence and there are more economic arguments. And if the Domco economists deploy apparently well-reasoned arguments, then they've got to be counteracted by the Commission. That's a million miles from saying there has to be exhaustive effects analysis in every Article 102 case, which were the words I think I heard from you. If you look at 50 years of jurisprudence, if the Court of Justice says in AXO that if a dominant company charges prices below average variable cost, that is an abuse, that's jurisprudence of the Court of Justice saying that that behaviour is abusive and illegal. Well, to my mind, is that not a presumption? So if the Commission then in its draft guidelines says we're going to have presumptions for certain types of behaviour, that's because that's what the Court of Justice jurisprudence says. So this idea
Object restrictions, object abuses in.
Well, I'm not
these
going to say,
cases.
I'm not going to say that predation is necessarily an object restriction. I will say that the Court of Justice, not the Commission, the Court of Justice in something like FIFA and Super League has acknowledged the existence of an abuse by object, because there are certain types of abuse that have no explanation other than an intention to exclude. AstraZeneca, of course, would be another example of that, where I basically mislead patent authorities into extending the duration of my patent protection by giving them false information. How much effects analysis does there have to be in a case like that? Do we have to resort to the as efficient competitor test in circumstances where a Donco has lied to public authorities in order to extend its monopoly? Of course not. So there are some kinds of cases where effects analysis is unnecessary or very little analysis is necessary. There are other cases like Intel, which are fantastically complicated. All of those rebate discount cases are horribly difficult. I've been trying to make sense of them for 40 years now. And if in the end it says this becomes a battle of the economists to persuade a court that my argument's better than your argument, well, so be it. I'm happy with that. And there should be a deep analysis of what's going on, but there are other cases where you don't need such a deep analysis. And can I just say one other thing, which is that a lot of people have objected to those draft guidelines because it introduced a two-tier test.
Departing from competition on the merits.
Was this competition on the merits? Yeah. And then secondly, was it exclusionary
effect? Yeah.
Now, okay, maybe the way they wrote that, I think the way they wrote that has somehow been misunderstood. But let me say my bit on this. If you go back to almost the founding judgment on exclusionary abuses, which I would suggest is Hoffmann-La Roche and the Commission in whenever that was, 1979 or something, there, the Court of Justice says abuse is an objective concept, and abuse takes place where somebody departs from normal competition, resorts to methods other than normal competition. Now, you could well say, whatever that means, what is normal competition? But they use the expression normal competition. What is competition on the merits? Is it not just another way of referring to normal competition? Because you get cases go to the Court of Justice on the AstraZeneca type abuse, for example, or Lithuanian railways, where a competitor asked to use a bit of railway track, and my response is to rip up the railway track, or I disparage a competitor's product so that the health community will not use the competitor's product rather than my product. How do we know that these are abuses? What principle do we make use of to say that is abusive rather than non-abusive? Do we do price analysis, cost price? Well, you can't do that when you're lying to patent authorities or ripping up railway tracks. Yeah. Do you use the hypothetical? It's not
pricing behavior, obviously. Yeah.
Do you use the hypothetical as efficient competitor? No, because that's that. Do you have precedent? No, it's the first time there's ever been a case like this. Well, how do I, a judge in a court, know that this is abusive behavior? Because whatever competition on the merits is, and I accept it may be difficult to define competition on the merits, I do know what is not competition on the merits, which is reacting to a request to use a railway track by ripping it up in circumstances where the person who wanted to use it was prepared to pay for its maintenance and repair. I don't think it's competition on the merits to go to a patent office and lie to it in order to extend the period of my monopoly protection. And the Court of Justice has used this expression, competition on the merits. I mean, we could do a search, an AI search, put in the search term competition on the merits in the Court of Justice. I bet you it would come up 25 times just like that. And so what I think the Commission is saying is you've got to compete on the merits. You mustn't compete not on the merits. And then it's saying, and of course, if it's an exclusionary abuse, you've got to then show exclusionary effects. And that's what it goes on to discuss. And then it says there are some types of conduct for which there are presumptions, and there are others for which there are no presumptions. Well, then you've got to have a full effects analysis. I have to say, actually, that's my understanding of the Court of Justice's jurisprudence of 50 years. So the idea that the Commission is trying to depart from the jurisprudence is nonsense. But and the final point I would make on that, of course, is that if in the end they issue guidelines which in some sense are a departure from the case law, well, it'll be for the Court of Justice to say so, because the Commission doesn't make the law.
Of course, it will be tested.
The Court of Justice makes the law. And just to make the point, incidentally, that there have been a few occasions when the Court of Justice has not followed what was said in the guidelines on enforcement priorities, which do not purport to state the law, but which set out what cases the Commission will bring. Because on something like margin squeeze and Telia Sonera, the test that the Commission proposed for taking cases was stricter to it than the actual law that was applied by the Court of Justice in Telia Sonera.
Yeah, that's a 2012 case, if I'm not mistaken.
Yeah.
Around that, yes, margin squeeze also.
Yeah.
We could write volumes on that. Professor, thank you. As I said before, I still have a bit of a feeling that something in these draft guidelines might be moving away from a more kind of economic-based analysis and path to enforcement of 102, resulting from a general idea that perhaps that kind of enforcement of 102 just leads to very long-lasting cases and endless litigation, and that's not effective enough as a kind of a way to enforce 102. But
and let me just say, Gonçalo. Okay, I've been very sort of demonstrative in expressing my opinion. I know that I'm a huge minority. I know that the majority of people who are vocal in this space would align themselves with you. That doesn't mean to say that I'm wrong, however.
I know. Well aware of that. Professor, one final topic for discussion, if I may, and this has to do, I mean, to kind of cover the whole spectrum. This has to do with merger control in Europe. I mean, in Europe and the UK, I think the trends are the same. And it has to do with jurisdiction and thresholds. And I think a general opinion on whether the current view by the Commission and many national competition authorities on merger control thresholds and jurisdiction isn't perhaps a bit too, how should I put this, too accommodating to a scenario of excessive legal uncertainty. And so just to try and be a bit more specific, after the ECJ kind of cleared the waters with its judgment in Illumina Grail, we kind of hope that there might be some efforts towards harmonizing thresholds and harmonizing criteria. However, what we've seen, if I'm not incorrect, what we've seen is the Commission continuing to kind of encourage member states to adopt call-in powers, which many countries already have, call-in powers for under-threshold deals, but without a real concern to ensure consistency or harmonization of the criteria under which these call-in powers might be exercised. And so it seems to me that we might come up in a few years with a scenario where we have maybe 27 different call-in regimes, one per each member state, and each of them based on a differing set of criteria, whether this is kind of more going towards a more wide discretion for the national competition authorities based on potential impact on competition or innovation, or adopting alternative revenue thresholds, or a more sector-specific focus, for example, on big tech, biotech, pharmaceuticals, these kind of sectors. And the question here is whether it might not be preferable, although obviously the path would be harder, to look at the issue head on and try and trigger a genuine debate on whether the essentially turnover based merger control, merger filing thresholds should be reviewed, in the sense that perhaps some other alternative thresholds should be added, but rather than in a kind of differing mosaic of calling regimes nationally, with a more harmonized approach. I mean, for example, Portugal is a rather exotic jurisdiction in this respect. We have a turnover threshold and we have a market share threshold. But I mean, perhaps it would make sense to debate potential criteria based on deal valuation multiples or some other kind of sector-specific focus, for example. How do you see this? Is this a cop-out from changing the law, or does it make sense to have this?
This all goes back to the Illumina Grail saga. And so the General Court upheld the Commission's adoption of jurisdiction in that case, and the fight went on to the Court of Justice, and the competition bar many people in the competition bar were hoping that the Commission would get reversed, which of course happened. And it happened, I seem to recall, during the ABA conference in Washington, and I'm sure that even more bottles of really expensive wine were drunk to celebrate the Court of Justice's judgment on that occasion. But I had been saying to law firms running up to the day of the judgment, be careful what you wish for, quite frankly. Because I would suggest that what we had before the Illumina Grail judgment is much better than what we've got now. Why do I say that? Because, okay, you've got Article 22. Could it be used in those circumstances at all? And it was arguable both ways, frankly. Just a literal interpretation of Article 22 suggested that the referral could be made. Okay, for perfectly respectable reasons, the Court of Justice decided differently. But what was the situation before the Court of Justice? That the Commission had written guidelines on the circumstances in which it would accept an Article 22 reference below the thresholds. And they were strict, they were clear, they explained what they were looking for, and they had accepted very, very few references on the basis of that guidance, which of course was binding on it. It wouldn't have been allowed to depart from that. It's a notice, it's gone into the OJ and all the rest of it. So it binds the discretion of the Commission. And then what happens? The Court of Justice says, no, this is all completely wrong. So what has happened since? Member states have all looked at it. Some want it, some don't want it. They have different ways of doing it. You've got value of transaction, I think, in Austria and Germany. You've got other systems in other jurisdictions. And so it's a complete patchwork across 27 member states. So when I used to say, be careful what you wish for, I now say, are you happy with what you got? Because the one effect produces the other. So I think it's a very unfortunate situation in which we now find ourselves, quite frankly. So you then ask the question, should we take the bull by the horn and actually reopen the merger regulation itself and look at the turnover thresholds? Well, I find the idea of trying to reopen the merger regulation a horrendous idea, because I mean, at the level of politics, I just think it would be monstrously difficult. And if you decide to start looking at thresholds, well, what else do you decide to look at the same time? And it would become long and protracted and controversial, and who knows where we would get to at the end of it all. So I think the situation is very unfortunate. I preferred the pre-Illumina situation. But let's face it, what are we talking about? We are actually talking about killer acquisitions. It's a very unfortunate term, it seems to me, because it preloads the discussion. Killer acquisition, how horrible is that? So we've got to do something about it. Now, I mean, we're all intelligent and sensible and knowledgeable enough to know that bright startups doing brilliant things and taking risks and investing and so on, and then cashing out by selling to a corporate giant somewhere. That is the way the market works, and you don't want to do anything to discourage that whatsoever. And I did notice in the autumn that Teresa Ribera gave a speech in which she said, we're wondering if we can provide some kind of screen that will provide certain kind of guardrails that could give some comfort to some people in that situation. But, have to say this, is there such a thing as a killer acquisition in this world? Is it conceivable that a dominant firm might see a competitor, an emerging competitor in a market, and then say at board level, we've got to get rid of them? Could such a thing ever happen? And then you look at that French Competition Authority decision in the autumn of last year, Doctolib, who acquired a competitor, Mondocteur, and there are internal documents of the company saying we must acquire it because we have got to kill the competition. If we do this, we will have a monopoly. Well, having seen that on the facts of a real case, it's going to be very difficult to persuade me that there is no such theory of harm as a killer acquisition. And if that can happen in a market, you've got to think of ways to deal with it. Now, of course, the French authority could use Article 102, because that's the consequence of the Towercast judgment a few years back. But the Commission could not use Article 102 because Article 21 of the merger regulation disapplies Regulation 1 and the powers in it to concentrations as defined. And that means any concentration, not just a concentration having a community dimension. So there is something there that needs to be looked at. And one way of looking at it would have been the pre-Illumina way. Another way of dealing with it is to have 27 different member states' laws, which is the way in which we're headed.
Yeah, so it looks like we're going to have to learn to live with significant uncertainty for deal making. I wasn't aware of that French case. It looks like someone didn't.
Doctolib acquiring Mondocteur. I've got it over. There's a pile of paper over there where I could find it. It's a decision of the French authority. It's a general abuse of dominance case. There are other abuses, but one of the abuses was the acquisition of the rival.
Yep.
And they were fined €50,000 for that element of the abuse. And that legal point, I'm pleased to say, is on appeal to the Cour d'appel in Paris. And I can well see it's the sort of thing that might end up in the Court of Justice in Luxembourg, because it's almost like, we've had Towercast. Where do we go next after Towercast? So a fascinating case, but an important case that your clients need to know about.
Oh yes, we'll look it up for sure. Looks like someone didn't get their competition compliance training, or if they did, they decided to ignore it. But in fact, internal documents now really seem to be.
Well, no. In fairness to
many
the
merger
client,
control cases, yeah.
In fairness to the client, the French Competition Authority in Towercast thought it couldn't apply Article 102 to that concentration. So they're in reasonable company in not knowing how the law worked.
Yes. Thank you very much for joining us. It's been very enlightening. We'll go back and do some homework based on this. It's been wonderful to have you. It's been a quarter century since I sat in the lecture halls at King's and had the privilege of being your pupil physically. It's been wonderful to see you again. Thank you for joining us.
Okay, take care. Bye-bye.
Thank you.
Join us again soon for the next episode of Thinking Competition.